Good morning, everyone. Welcome to our first provider webinar. I'm Shelley Sutton, Executive Director of the Kansas CLE Commission. Thanks for joining us today, and we really want to thank Washburn University School of Law, who is providing us with the technology for this webinar. As Glenn has mentioned in the chat box, if there are any technical issues on this presentation, we are taping and a video of the presentation will be available later, as will the written materials after the presentation is over. As many of you know, Kansas ushered in new rules governing CLE on July 1st, 2011. Today, I want to talk about four major areas of rule changes: instructional or written materials, non-traditional programming, ethics and professionalism credit, and law practice management. In addition, we will talk about the administrative side of offering CLE credit for attorneys licensed in Kansas. What is the process and what's on the horizon? First, let's talk about the written material requirement. Why are instructional materials required? First, it ensures that there is a thorough course preparation by the provider and the presenter. Just copying a set of cases or statutes without customized materials is not acceptable. Second, it ensures that attendees receive materials that are useful after the course is completed. Materials provided should be sufficient to assist the attendee when questions regarding the covered subject matter are raised at a later date. And it also serves as a general resource after the course. Third, it allows the Kansas CLE Commission to evaluate the quality and nature of the course when neither the application nor the agenda provides sufficient information about course content to allow evaluation. I think many of you have done a fantastic job of marketing your programs, but the creativity on some of the titles does tend to be a little bit of a challenge when we're reviewing programs. The rules have always required thorough, high-quality, readable, useful, and carefully prepared written materials be made available to participants before or at the program. A program with no instructional material will not be granted credit. Under the new rules, the requirement to provide written materials can be satisfied by providing printed copies or copies stored on electronic media, CD, or via download. But the materials still must be provided and delivered to the attendees before or at the program. If the provider does not provide printed copies to all attendees, they must make printed copies available to any attendee who requests them. How the material will be provided will be an issue between the provider and the attendee, but these rules will allow flexibility from the regulatory perspective. Let me repeat. The attorney no longer has to have a hard copy of the material in front of them. As long as you have provided the material to them before or at the program, the requirement is met. How the material is provided is now an issue between the provider and the attendee. Now, here are a few questions that we've received about the change in the written material requirement. If we email handouts to attorneys before the seminar, are we required to supply hard copies on site to those who don't bring a copy with them? If the attendee requests a hard copy, you can provide that to them after the program. By providing an electronic version prior to or at the program, you've met the standards for accreditation. In the presentations that we have done around the state to attorneys, we've asked them how they prefer to receive their materials. The response has overwhelmingly been hard copy. As I said earlier, this is probably going to be an issue between you and your attendees and how they prefer to receive the materials. Does the handout still need to be comprehensive? Yes. The material still must meet the standards of thorough, high quality, readable, useful, and carefully prepared written materials for it to be accredited. That hasn't changed. We want to make sure that those materials are useful to the attorney after the program. One of the most significant changes in the new rules is in the accreditation of non-traditional programming. Non-traditional programming is defined as a program accessed solely by an individual attorney. This means one attorney, one computer, or one telephone. These new rules allow much more flexibility with technology, and we've grouped them into 3 categories. Live transmission, which would be teleconference, video conference, or web conference. Pre-recorded video, which would be videotape, video CD, DVD, video file, or online video. And pre-recorded audio, which would be audio tape, audio CD, podcast, MP3, or online audio. So those of you who are familiar with Kansas and our rules prior to July 1 will recognize right away that this is a significant change for us. There are 2 new application forms for non-traditional programming. One is for the live programming and the other for pre-recorded. Here is the application for the live non-traditional program. It's available at our website under Forms and Applications. There is an application fee of $25, which is the same fee as we charge for an application for traditional programming. This is a one-time program offered on a specific date and time, hence the live non-traditional programming. If you're offering this program on more than one date and time, you can list all of them on one application just like you would with a traditional program. If you need to add a date after your original submission, you would need to submit a new application. Now here is the application for pre-recorded non-traditional programming. The application must be submitted with a $100 application fee, but the approval is valid through June 30 of that compliance period. Mark all of the formats that you're offering on this one application. So if you've offered a program in July and have not yet submitted it, you can still submit that. And that accreditation is valid until June 30, 2012. You would need to reapply for the next compliance period. Under the old rules, the provider had to submit the application for approval 30 days prior to the activity. Under the new rules, the provider still must submit the application for approval of non-traditional activity, but the provider can submit that application anytime during the compliance period. So that 30-day prior notice is no longer valid. If you have had a program that a Kansas attorney attended in July, August, September, and they're wanting Kansas credit, as long as you submit the application and meet the requirements for verification and interaction, we can grant credit for that program. You must have procedures in place to independently verify completion of the program, but the verification procedures may vary by format and provider. For live transmission, the teleconference, web conference, or webinar, you still have a login, log off time, but one suggestion would be the polling, some type of polling verification per 50-minute period. You will verify that the attorney has met the interaction verification requirements. How that attendance is reported is going to be something that we will work out with you. Some providers are filing attendance via email, and some are issuing an actual certificate. We're keeping a level of flexibility with this at this time. For pre-recorded audio and video programming, the provider will follow the same procedures. For example, verification for a course in the videotape DVD format for individual viewing might consist of an attorney reporting a course code to the provider after viewing a videotape, DVD, whatever. You would verify the accuracy of the code before issuing a certification of attendance. Again, we'll be working with the individual provider based on the format of program offered. I think many of you are working with other states and have met some similar requirements there. So it should be very easy for you to meet that requirement here. It's our biggest challenge, I think, with this non-traditional programming is getting the word out, both for you as providers and also for the attorneys. A lot of the attorneys still don't realize that this rule has changed. So we're trying to educate them by doing presentations around the state and hopefully reaching you all as providers to let you know that we do want to see these opportunities open up for the attorneys. Now, here are a few of the questions that we've received regarding non-traditional programming. Can a provider apply for live teleconferences after the event? Yes, that's fine. As I mentioned earlier, we no longer have that 30-day advance notice. Can attorneys apply for CLE credit for live teleconferences? No. At this time, we still require that the provider file all the applications. We have to make sure that the verification and interaction requirements are met for the court before we can accredit a program. And the best way for us to do that, at least at this point, is to work directly with the sponsor. Can an attorney receive credit for purchasing an MP3 file of a teleconference? Yes, surprisingly enough, it is true you can get credit for an MP3 program. Again, our rules have changed drastically. Assuming that the verification and interaction requirements are met, the provider would just need to submit the application for a pre-recorded non-traditional program. Again, that's available at our website, www.kscle.org. Do on-demand, online, and podcasts of the same content require two separate applications? No. All forms of an on-demand program can be submitted on one pre-recorded non-traditional programming application. Remember that this $100 application fee gives approval through June 30. So if you're offering that program as a podcast, as a streaming archived video, on CD, on DVD, all of those can be listed on that same application for approval. And we will just issue approval for each of those different formats. If a live presentation has already been approved, would the $100 application still apply for the pre-recorded format? Yes. That's a totally separate application. Remember, we have 3 types of credit we review: traditional programming, live non-traditional programming, and pre-recorded non-traditional programming. Each application must be submitted for the various formats of the program offered. Non-traditional programming is still limited to 5 hours per compliance period. However, the total length of a program is determined by the provider. If the online program is 8 hours, the maximum attendance the attorney can apply to the compliance period will be 5. This rule applies to programs accessed solely by an individual attorney. If a group of attorneys get together to watch a non-traditional program, it becomes an in-house program, and the application must follow the rules for in-house programming. There is a guideline for in-house programming available at our website as well, which kind of outlines what we need to see. This is one place where the sponsor, which would be the law firm or corporation, whatever, wherever the program is being held, would be considered the provider and would need to submit the applications 30 days prior to the activity for us to consider credit. Programming approved under non-traditional guidelines can be converted to a traditional program presented in a classroom setting in a central viewing location and advertised to a broad attorney population. This would include a video replay, CD, DVD, telephone, etc. A moderator must be connected in person via telephone or email to comment and answer questions. If you have questions on how to do that, please feel free to call our office at any time. We're more than happy to work through your questions on that, because I know it can get a little confusing at times. While the rules for in-house programming haven't changed, let's go back and talk for a minute about that in-house rule. The rules define an in-house program as traditional programming given for a select private audience of the same law firm, corporation, or single governmental entity, and not open for attendance by others in the legal community generally. This includes a program offered by invitation and a program that's not advertised to a large attorney population. Again, call us with questions. If you are working with law firms to offer programs, we can help you walk through that process, and it really is very simple once you understand those guidelines and rules. Now, ethics and professionalism is another area that there's been some slight changes. What was previously known as professional responsibility in Kansas will now be referred to as ethics and professionalism credit. At least 2 hours of the 12-hour requirement must still be completed in this area. Ethics and professionalism issues included as part of another topic will not qualify for ethics and professionalism credit in Kansas. Ethics and professionalism topics must be in identifiable blocks of time on the program agenda. I know that in some states we see agendas that come from there that have a session, say 45 minutes, and there'll be a notation there that .25 focuses on ethics. Unfortunately, we cannot grant credit in that way. It's got to be something that's totally separate and identified on the program agenda for us to consider ethics and professionalism credit. Now, the Commission occasionally receives applications for approval of ethics credits that don't pertain to the ethics or professionalism issues specifically applicable to attorneys. These programs may meet the requirements for general CLE credit, but are not eligible for ethics and professionalism credit. Examples of topics that would not qualify for ethics and professionalism credit: ethics in government, mediation ethics, litigation tactics, or business, corporate, or medical ethics. But these topics definitely would qualify for general credit. Law practice management. It's been a topic that has been requested for many, many years, and as we have spoken with many disciplinary administrators as part of our organization of CLE, we've had some come in and talk to us. I've talked with our local disciplinary administrator at length over the years. Law practice management is definitely an area that does cause a lot of problems for attorneys. So as of July 1, attorneys have the option to earn up to 2 hours of law practice management each compliance period. This is not a requirement, but it's an option. One thing to realize when you're submitting an application, everything is not law practice management. I realize sometimes you want to make it law practice management, and that seems like a logical thing to do, but it's not in the best interest of the attorney, and I'll explain a little bit more about that. The rule defines law practice management as programming specifically designed for lawyers on non-substantive issues that deal with the means and methods of enhancing the quality and efficiency of an attorney's service to an attorney's clients. Topics include issues relating to the development and management of a law practice. That would include client relations and the technology needed to promote efficient, economical, and competent delivery of those services. Also technology, law firm economics. Now, programming accreditable under the ethics and professionalism requirement are not subject to the 2-hour law practice management cap. It is important to note that the course must focus on the legal profession to qualify under the law practice management option. Just putting a legal wrapper on a cover is not enough. Most of you out there are doing primarily programs for a legal audience, an attorney audience, but occasionally we'll see programs that come through that may be fairly general in topic, communication for fill in the profession. That's not going to be something that we're going to accredit. So keep that in mind as you're working on your plans for programming. Now here's a question that we've gotten recently regarding law practice management. I applied for law practice management, but you gave me ethics credit instead. Why would this happen? We are going to assign credit however it will be the most beneficial for the attorney. If the program had been approved as ethics before the law practice management option, it's going to continue to be considered ethics. Only those sessions that would not have been accredited before July 1 will most likely be considered for law practice management. We definitely are including things under ethics and professionalism. There are many things that would have been approved in the past that are law practice management, but are more ethically or professionalism issues as opposed to straight law practice management. Really, this law practice management is giving us the option to accredit things that we haven't been able to accredit before. The rainmaking, the marketing, the economics of a law practice, all of those things are going to be accredited now. So if you see a change when it comes back with the approval, don't worry about it. Call and ask us and we'll help you understand what the issue is on that. But we are going to make those adjustments as we need to make sure that the attorney gets the most credit possible. Now we get many questions about the application process. Let's talk about that. To consider a program for possible credit in Kansas, you must submit the application for approval of CLE activity with a copy of the program agenda. For an agenda, we do need beginning and ending times because we have to be able to identify the block of time if it's going to fall under any of those caps. We're going to specifically look through those agendas very carefully to make sure that we can accredit everything that is possible under our rules. We will accept the CLE-Reg uniform application for traditional programming. Again, there is a $25 fee that must accompany that application. Also, remember, if you have multiple dates and locations for a program, you can list those on one application. We don't have blanket approval or accredited sponsors. Each application is reviewed on its own merits upon receipt. Because of our volume, if you do add additional dates and even locations, and the program has been approved prior, you do need to submit a new application. Remember, just because a program has been approved before, don't assume that it will be approved again until the application has been reviewed. Please submit the application as early as possible. Depending on the time of year, it could take up to 30 days to process an application. I think that's pretty accurate for most states, and those of you who've been in the business a while understand the ebb and flow of accreditation and attendance. While we would like to see attorneys attend things throughout the year, and we hope that they will, we all know that there's going to be a huge spike in applications and attendance from, for us, March through August. No question, because we're dealing with year-end June 30, and of course everybody needs something accredited at that point. So keep that in mind as you're submitting paperwork. Once a program is approved, we'll issue to you the Kansas Notice of Accreditation. This is the application and the affidavit that has to be signed and returned for the attorney to register credit. Part of the agreement that you make when we accredit your program is that you'll follow our guidelines to get approval and make sure the attorneys get attendance. That includes making sure attorneys licensed in Kansas receive this affidavit and that you verify their attendance. If we have questions on an attorney's attendance, you need to be able to tell us definitively whether the attorney was in attendance and how long. We don't accept attendance lists. Many of you have asked about online applications and attendance reporting. Those are both things that we too would like to see. We are talking with our database provider. They're aware that this is something that we want. Unfortunately, as you know, it takes time and money. We're a very small staff. I will say I neglected earlier to introduce Cindy Chafin, who many of you have talked to. I know I can't get her on camera at this point, but she is running the PowerPoint today, helping keep me on task. And as always, she's available to answer your questions as well. But with Cindy and I both being here for this webinar, our office is down to one person who is part-time. So we're very efficient, but we're very small. As we start developing other options, we will definitely let you know because we want to see them too. Now, on these notices of accreditation / affidavits, it's critical that these affidavits be filed within 30 days of the activity. Since our transcripts have gone online, there is a sense of immediacy. An attorney attends a program one day and they fully expect to see it online the next. Providers who are holding programs in state are required to collect the affidavits and return them to us within 30 days. Sooner is definitely better than later. For out-of-state programming, we tell the attorney it's their responsibility to file any and all paperwork. We realize that those of you who are on a national level are dealing with a number of states, and our basic rule of thumb for the attorney is that it's their responsibility to submit any and all paperwork. We do recommend that providers maintain the records for programs they offer for a minimum of 3 years, but 5 years is ideal. One note to remember in filing timely paperwork, we do start assessing late fees 30 days after the end of the compliance period, and that is a $50 late filing fee. We have had situations where sponsors, providers have not gotten the paperwork to the attorney or not gotten the affidavits back into our office, and the rules do state in that situation the provider is responsible for paying that late filing fee as opposed to the attorney. It also poses a very interesting customer service problem for you. But we have had it happen where the provider had to pay up to 100 attendees because the affidavits were not filed timely. So just keep that in mind as you're working through the year. It just keeps things moving. The attorneys can check their online transcript regularly to know exactly where they are. Since we are an affidavit-based state, it's really easy for an attorney to know exactly where they are as long as the paperwork is being filed as it should be. Now, I know this has been a lot of information in a very short period of time. I don't know that you have any additional questions at this point. I would like to think that we covered everything in a very quick and efficient way, but I have no illusions to that. So if you have some questions and want to type that into the chat. I see we have somebody typing. Oh boy, everybody's typing. Okay, this could be interesting. But you know, this has just been an excellent way for us to reach out to you and hopefully answer some of those questions that you're having. This is one way. As always, our staff is available to help you as much as you can to deal with all of this. Now, we have one question. Do the attendance records have to be hard copy, or can it be kept electronically? I do think it could be kept electronically. That's an interesting question, and I'd probably like to think about that a little bit more and talk to you a little more about that. Are you thinking of scanning those signed affidavits in? If it's, you know, the main thing that I want to see with all of this is that you can verify the attendance of the attorney. How you do that, I don't care, but you need to be able to verify the exact number that they've attended, that they were there for the whole program. any of that. So just keep that in mind. We'll continue to work with that. Okay. Okay, we have a question on instructional materials. I think we'll hold off a second and go back to that, if that's okay. There's a question about waiving the application fee. Yes, for those programs that are offered free, we will continue to waive that $25 application fee. So that's not a problem at all. So as you have been, just keep writing request for waiver, no charge. Normally we see those as 1 hour programs, 2 hour programs, you know, more local than probably national. Okay, can you explain what type of awarded program you consider acceptable? Again, we're working with each provider independently on that, but what I have been seeing is there's just like a number or a word that's embedded in that pre-recorded program, and then that is turned back into you, the provider, to verify the attendance. And at that point, you know, I think we're open. It doesn't have to be anything very complicated, I don't think, but you know, as you start developing that, if you want to contact us, we'll work through it with you. Let's see. Okay, you mentioned online attendance recording possibly in the future. Is there talk about making the application process electronic, perhaps even by email? Yes, we are looking at all of that at this point. Our biggest challenge with accepting things by email is the fact that we are very small. We just don't have the capacity to do that at this point. But we are looking at some options. Again, we're talking with our database provider, trying to figure out what we can do to offer online applications and attendance reporting. So as we come up with options, we definitely will let you know. If a class deals with attorney ethics rules as they apply to government lawyers rather than the government's ethics rules, will that qualify for ethics and professionalism credit rather than substantive credit? Absolutely. The key there is it's lawyers, it's government lawyers, as opposed to lobbying ethics, or maybe an easier way to say that is if it's a program that any employee in the government is going to, that's not going to be something that's focusing on legal ethics. So that's going to be kind of the discriminator for us. Can notice of accreditation forms be emailed to an attendee, signed and returned electronically for submission, or does the live signature have to be obtained live? There are ways to do that. You can fax that notice of accreditation to the attorney and they can sign it and then mail it directly to us. We do need the actual form, so you're very easily you can send that to them. If you want them to send that original copy back to you and then send it to us, that's okay. But for our purposes, we do want that original affidavit with the signature at this point. Here's a question. We offer pre-recorded online audio-video programs that include a 10-minute question quiz at the end. Am I to understand this is now a format you consider? We verify by quiz and time segments. Leslie, call me. Yes, I think we're moving towards that. I'd want to see a little bit more about how it works, and we'll definitely take a look at that. Let's see, the application process. Multiple dates, locations. I submit 2 applications for one program that are held in St. Louis and Kansas City. Do I need to just do that? Do one app for now with $25. Yeah, that's really the best way for you. It's a better value for you. You know, with our volume, we try to catch those when they come in, but there's just no way for us to do that. So yeah, if you have the same program offered in 2 different dates and locations or 10 different dates and locations, put it all in one application. The only caveat that I would put there is make sure that we can read it. That's a challenge. If you need to attach a list to the application, that's fine. Please feel free to do that. What about the notice of accreditation for non-traditional programs? Is there anything the attorney must turn in within a given time frame? What about the late filing fee? Does it apply to non-traditional programs too? Let's take the first question first. Really, we want that affidavit in within that 30 days, just so that it's reported and it's on the attorney's online transcript. We will work with you to figure out how that's going to happen. Is it going to be a certificate? Does it make more sense for you to email us? You know, as always, give us a call and we'll be happy to work with you about that. The late filing fee, it would apply to everything, non-traditional programs as well. So I think the important thing to remember, just so you don't get caught at the end of the year, is make sure that everything is getting filed within 30 days of whatever the activity is. Sooner is better. You know, if you want to turn it around in a week, we're not going to turn it back. Does the Kansas CLE Commission have any objections to out-of-state programs sending in the attorney accreditation affidavits? No, I mean, you are more than welcome to send them in. And in fact, we like that. I think the most challenging thing for us are for programs that are held on the border at a law firm, and the next day we see 50 envelopes from that law firm for the same program. You know, I think it makes more economical sense for somebody to collect those and send them all in at once. But again, that's totally up to you. But if you want to send them in one packet, great. Will information pertinent to GALs and parent attorneys in sync cases be able to be approved now if it's pertinent to their having a better understanding of their clients' needs and representation of parents and children in sync cases? I think those have all been accredited prior. I'm not sure if there's something different there. We don't accredit as GAL because we don't track that credit. That's something that the local judge would need to identify as accreditable for meeting that suggested requirement. But you know, for the most part, if it's benefiting an attorney's practice, we're going to accredit that. Cindy, can you pop that down just a bit? Yeah. We offer 2 traditional programs a year for which we as sponsors apply for credit as out-of-state sponsors. We have begun to offer webinars for which we verify attendance through a quiz we send to attendees and issue a certificate of attendance. Can individual attorneys that pay for our webinars apply for credit on their own? No. Webinars are considered non-traditional. Those have to be submitted by the provider for us to consider credit. Would a teleconference be considered traditional if offered in-house with in-house attorney designated moderator for attendance, sign-in, sign-out? Yes. If you are offering a teleconference in a group setting, you have somebody there who's keeping track of attendance, the attorneys are all sitting around a conference table listening to this teleconference, yes, that's going out of the non-traditional angle and going in to the traditional in-house program. Again, if you have questions on that, call us. Would a seminar be considered traditional if it is a live video replay with lawyers in a classroom and with a moderator present? Yes, that is traditional in our sense. And I think the main thing to remember when you're talking about traditional versus non-traditional is the fact that traditional is in an actual classroom setting. Remember, our definition of non-traditional is one attorney, one computer, or one telephone. Would a seminar be considered traditional if it is a live video replay? Oh, is that the one I just answered? Yeah. Oh, sorry. We're getting another one in. Can you please clarify the waive of the $25 application fee? In-house programs are responsible for the $25 application fee. We're only talking about waiving fees for the public programs, not for the limited programs. A certificate can serve as the affidavit that you send to sponsors to provide live programs. If so, do the attorneys need to sign their own certificates before sending them to you? Absolutely. If you have that notice of accreditation affidavit, you have to provide that to the attorney, and the attorney is responsible for completing that. That is an affidavit to the court. So very important that you do not touch that part, because that's going to invalidate an you can I just lost my train of thought. Okay, sorry. Anyway, one other question, and then we're going to move on real quick because we are running out of time. And if you still have questions after this, feel free to email us, and we'll be happy to answer your questions. Yes, we're still available for presentation to firms regarding the rule changes, and yes, CLE credit is still available for that. We're doing a 1-hour rule change program around the state. There was one question about written materials. I don't know if the question was regarding why they're required or what is required. I'm thinking it's probably what is required. Yes, you have to have written materials. You can provide them electronically now. And no, a hard copy does not have to be in front of the attendees. You more local sponsors who've been offering programs in Kansas for a while, are probably still thinking a little bit about the fact that when they were able to bring in a laptop, they had to have the laptop in front of them to review the electronic materials, but that's no longer the case. As long as you provide those materials before or at the program, you're good to go. So keep that in mind. We're going to go ahead and wrap this up for today. As I said, email us if you have questions. We'll be glad to answer them, or call our office. Sometimes it's easier to call, and we can talk you through the process. It's very easy, very quick. We're very excited that you joined us today. We're really looking forward to working with you in 2012. One note, we have scheduled our Spring Provider Conference. That will be April 18th, 2012. In Topeka. For those of you who have not emailed or not attended our provider conference before, it is an opportunity. We do have our full board there. The commission is there, fully interacting with the participants. When possible, our liaison to the Supreme Court is available, which is really nice because I don't know anywhere else you have that kind of access. Our email address for questions, the easy way would be cleadmin@kscle.org. You can also respond to the email that Cindy sent out with the instructions for this webinar, and that's a valid email address as well. So as always, have a good 2012. We look forward to talking to you soon. This video, if you have questions or want to go back over something, will be available online probably very soon. So we look forward to working with you and talking with you again soon. Thanks, everybody.